Right now, today, the Supreme Court just handed down a decision that changes everything about how the government can track you. 6-3. That's the vote. And what they just ruled affects every single person in America who carries a cell phone in their pocket, which, let's be honest, is basically all 330 million of us. Here's what just happened. The Supreme Court ruled that when police want to know who is near a crime scene, they cannot just walk up to Google and demand the location of every single phone in the area. They cannot cast a digital net over an entire neighborhood, an entire city block, an entire parking lot, and pull in innocent people along with whoever they're actually looking for. For the first time in history, the highest court in this country just said, your location, where you go, when you go there, how long you stay, is protected by the Fourth Amendment. The same Fourth Amendment that's been on the books since 1791, the same one the founders wrote to stop the government from searching your home without a warrant. Today, the Supreme Court said it applies to your phone, too. And if you think this doesn't affect you because you've never committed a crime, stick around. Because that's exactly the point. So this ruling exists because innocent people, people who did absolutely nothing wrong, were getting swept up in these searches. 19 people in this case alone had their private location data handed to the government before a single suspect was even identified. So today we're breaking down exactly what the Supreme Court ruled, how the case got here, how the justices split, and I promise you, the way they split is not what you'd expect. And what this means for your privacy going forward. Before we get into it, if you care about your rights, your privacy, and what the government can and can't do with your personal data, hit that subscribe button and tap the bell so you don't miss the next ruling. Because this court just released a wave of decisions and we're covering every single one of them. Let's get into it. The crime that started it all. To understand why today's ruling matters so much, you have to go back to 2019 to a quiet credit union outside Richmond, Virginia. A man walked in, topped the place of nearly $200,000, and walked out. No name, no plate number, no fingerprints worth anything. Just grainy security footage showing a man on a cell phone. Standing near the building right before the robbery happened, police were stuck. They had no leads, no suspect, nothing to go on except that one detail. Somebody, somewhere, was on their phone near that bank around the time of the robbery. So law enforcement turned to a tool that's become more and more common over the last several years, a geofence warrant. Here's how it works. And once you understand this, you'll understand exactly why this case ended up in front of the Supreme Court. A geofence warrant doesn't target a person, it targets a place. Police draw a virtual boundary, a fence around a location, like the bank in this case, and for a specific window of time. Then they go to Google. Because Google's Android operating system and Google Apps track location on hundreds of millions of devices through a feature most people don't even realize is running in the background, police demand that Google search its entire location history database and hand over information on every single phone that crossed into that fenced area during that time window. Not one suspect. Every phone, every person, whether they robbed the bank or whether they were just walking their dog past it. In this case, that first sweep pulled in the location data of 19 separate people, 19 completely anonymous device records, handed over because they had the misfortune of being near a bank at the wrong time. From there, police narrowed it down. They asked Google to expand the search window and give them 2 hours of movement data, both inside and outside that original fenced area, for 9 of those devices. And then they narrowed it again, and finally demanded Google reveal the actual names, emails, and phone numbers behind 3 of those accounts. One of those 3 names was Okello Chatri. Based on that chain, narrow, unmask, Chatri was identified, arrested, and ultimately convicted. He ended up sentenced to nearly 12 years for the robbery. But here's the problem his lawyers raised, and it's the exact problem the Supreme Court just ruled on. This entire process flips the Constitution upside down. Normally, the government needs probable cause pointing at a specific person before they can search that person's information. This process worked backwards. Police searched first, swept up dozens of innocent people's private data, and developed their suspicion afterward. His attorneys argued that's exactly what the Fourth Amendment was written to prevent, the government rifling through everyone's belongings on the off chance they find something useful. And that argument made its way year after year, court after court, all the way to the 9 justices of the United States Supreme Court. Now look, if you're just finding this channel, this is exactly the kind of ruling we break down here. Real cases, real impact. Explained in plain English, no legal jargon, no spin. If that's valuable to you, Smash that like button right now. Drop a comment telling me where you're watching from, and make sure you're subscribed because there is a lot more coming out of this court this week. Now, let's talk about what your phone is actually tracking about you, because once you hear this, you'll understand exactly why the justices took this case so seriously. What your phone really knows about you, most people have no idea how much their phone tracks them. So let's talk numbers. According to figures cited in the court's opinion, over 500 million people worldwide have location history enabled on their devices. Most of them didn't sit down and carefully decide to turn it on. Google prompts you over and over to enable it. Sometimes your phone tells you certain features flat out won't work, right? Unless you do. Once it's switched on, here's what happens. Your phone logs your location roughly every 2 minutes. Not your general area, your exact position, accurate in many cases to within 20 meters. It's precise enough in some circumstances to tell which floor of a building you're standing on. Think about what that actually means. Every coffee shop you stopped at, every doctor's office, every late night you spent somewhere you didn't tell anyone about, every church, every protest, every bar, every ex's apartment, all of it. Logged, time-stamped, and sitting in a database, not because you handed it over for any investigation, but because you simply own a smartphone and didn't dig through 7 layers of settings to turn it off. The government's argument in this case was that none of that matters constitutionally for 2 reasons. First, they argued this was only a short-term search, about 2 hours of data, so it shouldn't require the same level of constitutional protection as long-term surveillance. Second, and this is the bigger one, they argued that because people voluntarily use Google and voluntarily share that data with a private company, they've given up their expectation of privacy. This is an old legal idea called the third party doctrine. Basically, if you hand information to someone else, like a bank or a phone company, you can't claim it's private anymore. The Supreme Court rejected both arguments, flat out. Justice Elena Kagan, writing for the majority, said the Fourth Amendment doesn't come with some kind of grace period. It doesn't matter if police only look for 2 hours instead of 2 weeks. A short search can still expose deeply personal, deeply private information about your life. The Constitution, she wrote, makes no exception for officers who only crack the door open partway. And on the third-party doctrine, the idea that using Google means giving up your rights, the court said that's simply not how modern life works anymore. Carrying a smartphone isn't some optional luxury you can just choose to avoid. It's become close to mandatory for functioning in modern society, for work, for navigation, for communication, for everyday survival. Using the apps that come with that phone doesn't mean you've signed away your constitutional protections to the federal government. This is a massive deal, because for years, law enforcement and prosecutors have leaned on that third-party doctrine to get around warrant requirements entirely. Today, the Supreme Court drew a hard line and said, not for your location data, not anymore. How the court actually ruled. So here's exactly what the Supreme Court decided in plain terms. The justices ruled 6-3 that obtaining someone's cell phone location history through a geofence warrant counts as a search under the Fourth Amendment. That means the government cannot simply demand this information without meeting constitutional standards. They need to justify it the same way they'd need to justify searching your house. This builds directly on a major 2018 ruling called Carpenter versus United States, where the court first said that obtaining historical cell site location data from phone carriers required a warrant. Today's ruling pushes that protection even further, because the justices noted that geofence location history is even more precise and more invasive than the older cell tower data at issue in Carpenter. But, and this is the part a lot of headlines are going to gloss over, the Supreme Court did not throw out Chaudhry's conviction. They didn't declare him innocent, and they didn't say the evidence has to be thrown out. Instead, the court sent the case back down to the lower courts, specifically the Fourth Circuit Court of Appeals, to re-examine the case in light of this new ruling. So while the court established the constitutional principle, it left it to the lower courts to figure out whether, in this specific case, the search was conducted in a reasonable way that might still hold up. In other words, the rulebook just changed for every future case, but Chaudhry himself is still waiting to find out what happens to his conviction. Now here's where it gets really interesting, how the justices actually split on this. Because if you're expecting this to break down along the usual conservative versus liberal lines you see in most headlines, you'd be wrong. Justice Kagan wrote the majority opinion. She was joined by Chief Justice Roberts, along with Justices Sotomayor, Kavanaugh, and Ketanji Brown Jackson. That's a mix of justices typically labeled liberal and conservative, standing together on this one. Justice Jackson, joined by Justice Sotomayor, also wrote separately to underline just how dangerous she believes this multi-step narrowing process is. Their concern was that the three-step system, search everyone, narrow it down, then unmask names, gives police what amounts to total control over who gets investigated next, with no judge checking their decisions at each step along the way. Once that initial warrant is signed, officers are the only ones deciding who to zero in on, with zero oversight in between. Justice Gorsuch wrote his own separate opinion, taking an even more aggressive stance grounded in the original text of the Constitution. Gorsuch argued that we shouldn't even need a complicated balancing test for this. He said your location history is, in plain terms, your personal property, your papers and effects straight out of the literal text of the Fourth Amendment, and the government simply has no right to go searching through it without justification, full stop. Then you have the dissent, 3 justices who disagreed entirely with the majority, Alito, Thomas, and Barrett. Alito wrote a sharp dissent accusing the majority of ruling on outdated technology, since some companies have already changed how they store this kind of data. He warned that this decision will send shockwaves through how law enforcement investigates crimes going forward, and argued it will make it significantly harder for police to solve cases, particularly ones like this one, where they have no leads and nowhere else to start. So you've got privacy hardliners on one side wanting to go even further than the majority did. You've got the majority drawing a firm middle line, and you've got a dissent warning. This is going to cripple police investigations. That's the full spectrum of where the country's top legal minds landed on this. And it tells you this issue is far from settled. I want to know what you think. Drop a comment below. Do you think the Supreme Court got this one right? Or do you side with the dissent that this is going to tie law enforcement's hands when they're trying to solve real crimes with real victims? Scroll down and let me know. I read every single comment. And if you haven't already, now's a great time to hit subscribe, because we're covering every major ruling coming out of this court, and there's several more we still need to break down. Why this matters for you? Let's step back from the legal jargon for a second and talk about why this actually matters to you sitting at home watching this video. This ruling isn't really about Okello Chatri anymore. It's about every single person who carries a smartphone, which, statistically, is almost everyone watching this right now. Before today, the rules around geofence warrants were murky. Different courts around the country had ruled differently. Some said these warrants were fine. Others said they violated the Constitution. Law enforcement agencies were using this tool in cases across the country without a clear national standard. Today, the Supreme Court settled that question for the entire country. Location history is protected. Police need to clear a real constitutional bar before they can demand it. Think about what that protects against. Imagine you went to a protest, any protest, on any side of any issue, and police decided to draw a geofence around the entire area afterward and pull the identities of everyone who attended. Imagine you visited a medical clinic, a lawyer's office, a place of worship, or simply someone's house you didn't want anyone to know about. And that information could be scooped up in a digital dragnet just because you happened to be in the wrong place at the wrong time near someone else's crime. That's the world this ruling pushes back against. The court essentially said the government cannot treat your location like it's free for the taking just because a tech company happens to be holding onto it. At the same time, it's worth being honest about the limits here. This ruling does not ban geofence warrants outright. Police can still use them. They just need to meet a higher bar with real judicial oversight. Rather than sweeping up everyone first and sorting out the innocent people later, there's also a wrinkle worth mentioning. Around mid-2025, Google made changes to how it stores location history, shifting more of it onto individual devices rather than centralized company servers, which, according to the dissent, makes a lot of this specific kind of warrant harder to execute against Google going forward anyway. Critics argue that means today's ruling, while symbolically massive, might only have limited practical effect on this exact company moving forward. But legal experts are clear that the constitutional principle the court just established applies far beyond Google. It applies to any company holding this kind of sensitive data. And it sets the legal standard for fights over similar surveillance tools for years to come, including future battles over things like AI chat logs, keyword searches, and other digital footprints law enforcement has increasingly tried to access. That's the bigger picture here. This wasn't just a ruling about one bank robbery in Virginia. It's a foundational decision about how far the government's reach extends into your digital life. And today, the Supreme Court said that reach has limits. What happens next? So what happens from here? For Okello Chatri, His case now heads back to the Fourth Circuit Court of Appeals, where judges will have to apply this new ruling and decide whether the original search of his data was conducted in a reasonable way or whether the evidence used to convict him should ultimately be thrown out. That process could take months, possibly longer. For law enforcement nationwide, this ruling sends a clear message. The days of sweeping geofence warrants that scoop up everyone in an area before identifying a single suspect are over, or at minimum, severely restricted. Agencies will need to work with prosecutors and courts to build narrower, more targeted requests that can survive constitutional scrutiny. For privacy advocates, this is being called a landmark win. Organizations like the ACLU have already praised the decision as critical protection against invasive government searches. Legal experts are calling it one of the most significant digital privacy rulings since the original Carpenter decision back in 2018. And for Congress, several policy voices are already pointing out that this ruling highlights a bigger gap, the fact that lawmakers still haven't passed clear, modern legislation governing how the government can buy or demand access to Americans' digital data. Some experts argue this ruling should be the push Congress needs to finally act. For you and me, the everyday people carrying these phones around every single day, this ruling is a reminder that the fight over digital privacy is far from finished. Technology moves fast. The law is still catching up. And rulings like this one are going to keep happening as more and more of our lives get tracked, stored, and potentially handed over to the government, one database at a time. So that's the breakdown of today's massive Supreme Court ruling, a 6-3 decision that officially extends Fourth Amendment protection to your cell phone location history and puts real limits on how police can use geofence warrants to dig through the private movements of innocent Americans. I want to hear from you. Do you think the court made the right call here? And does this make you feel safer? Or do you worry this is going to make it harder for police to catch dangerous criminals? Let me know in the comments. I read every single one, and I'll be pinning some of the best responses. If this video helped you understand what actually happened today, do me a favor and hit that like button. It genuinely helps this channel reach more people who need to see it. Subscribe if you haven't already, and turn on that notification bell, because the Supreme Court just dropped a wave of major rulings this week, and we're going to be covering every single one of them as they come in. Thank you all so much for watching and for supporting this channel. Stay informed, stay engaged, and I'll see you in the next one.